Thank you, Mr. Chairman. I'm going to go with Solicitor LaCour. As you mentioned in your opening statement, emergency provisions are an important part of the business of courts. There is nothing unusual about the federal court using its equitable power to grant emergency relief to parties that come before it through preliminary injunctions and temporary restraining orders. Lower federal courts do so regularly. How does the Supreme Court's emergency docket differ from lower court decisions making with respect to injunctions and temporary restraining orders?
Ranking Member Grassley, you're correct that similarly, I mean, we've faced TROs from district courts where we have received the order from the court orally from the bench with no written order. I mean, these are emergency situations where courts need to act quickly. I think one of the difficulties the Supreme Court might have that a single district court judge might not have is that a district court is writing for himself or herself alone, whereas the justices have to try to convince at least 4 of their colleagues, if not more, to join a particular opinion. I do think that is potentially one reason why the opinions are a bit shorter than you might get from the merits docket, or sometimes you only get the order itself. But again, that happens as well at district courts and at courts of appeals.
Same to you. Without the Supreme Court's emergency docket, how can litigants whose fundamental rights are at stake seek immediate relief?
I mean, they can seek it from lower courts, but there's no principled reason why the lower court necessarily should have the last word as opposed to the highest court.
To you also, in response to a question for the record, Elizabeth Perloguer, this administration's nominee to be Solicitor General at the federal level, suggested that, quote, nationwide injunctions generally exceed district courts' constitutional and equitable authority, end quote. If the district court issues a nationwide injunction that exceeds its authority, is it an appropriate use of the Supreme Court's emergency docket to stay that injunction pending appeal?
I believe it would be, Ranking Member Grassley.
Okay. Based on your experience litigating cases before the Supreme Court, do the court's emergency proceedings provide parties sufficient opportunity for briefing and presenting their arguments?
I believe they do. We could always use more time, but we've been able, oftentimes, for example, in the Dunn v. Smith case I referenced earlier, we had less than 24 hours, but we worked through the night and we presented a strong case to the court, I thought, and Mr. Smith's counsel was able to represent him well, and he ultimately prevailed in that particular emergency proceeding.
Ms. Mascott, why would it be unusual or problematic for federal courts to resolve new and complicated procedural questions in the context of emergency application for relief?
Well, I think here in the particular motion involving the Texas case, the question was really whether the court had jurisdiction to be able to issue an order against any of the parties. And I think it was clear from the information that it gave us that it had serious questions that it did. And so it declined really to step in and change the status quo of what had happened in the lower courts in that case, but recognizing that there were potentially serious constitutional questions. But I think in the discussion today, it's really important generally to keep in mind that the Supreme Court does not reach out and control its docket. It's resolving matters that are brought to it. It's sometimes up through regular petitions for cert, and then sometimes through requests for emergency relief. And again, particularly with the Texas case, that bill was enacted in May, and litigants waited months to bring the request. And so if the court was rushed in its consideration here, again, it was responding to the timing of the parties that brought the matter to it. And if folks are concerned here today, it seems to me the decision there not to step in would be consistent with concerns here that the court not step in too quickly.
Yeah. Last and short question to you. Can federal courts enjoin laws rather than specific parties? Why or why not?
Sure, Senator. Under Article 3, the federal judicial power extends just to cases or controversies. So the court's got to be acting against specific parties and specifically does not have the power to generally review legislation. But thankfully, we have legislative bodies that we can go to petition for policies to be reviewed and not look to the court to answer every policy question for the country.
Thank you, Mr. Chairman.
Thanks, Chairman, former Chairman.